pandemic, telehealth services became a lot more prominent, but not every medical clinic or allied health practice offers them yet. And not everyone that does necessarily does so on a legally compliant basis. If you are already providing telehealth services, but you haven't thought through some or any of these legal issues, don't fret. Just check in with your legal counsel to confirm whether any formal remediation measures will be required and plan to be more diligent about compliance on a go-forward basis. Now, without further ado, let's talk about some fundamental legal and logistical issues that you should consider before rolling out telehealth services. First, let's talk about licensing and jurisdictional requirements. Providers must be licensed in the state where the patient is located at the time of the telehealth session. This means that if the practice intends to see patients across state lines, each provider must be licensed in each of those states. There are some exceptions for temporary, emergency, or incidental services, or services relating to continuity of care, or even vacations, but they are often very state-specific and limited. You typically need to notify the state's medical board and also clear it with the patient's insurer to ensure payment. And the list of nuances and exceptions to these exceptions goes on. Thus, as the default rule, you should expect to be licensed in the state in which your patient is physically located. Some states offer telehealth-specific licenses that do make it easier for providers to offer services across state lines. You should investigate whether any such licenses are available for your practice's scope of care. As just one example, the Psychology Jurisdictional Compact, or the PsyPact, is an interstate agreement that allows licensed psychologists to practice telepsychology across state lines in participating states without needing separate licenses. As of the filming of this video, about 40 states are PsyPact states, including Georgia and Texas, and legislation has been introduced in several other states, including California, which offers significant flexibility for telepsychology service providers. Ensure that the services you plan to offer via telehealth are allowed within the scope of practice for the provider in that state. A lot of these exclusions largely come down to the inability of technology to replicate hands-on care or specialized equipment. Naturally, you cannot perform orthopedic or dental surgery remotely, or provide a pap smear over the internet, or have an MRI scan from your patient's living room couch. Although goodness knows in a few years, this might be outdated. But as of now, clinicians, clinical directors, and patients alike are sometimes surprised by telehealth's limitations imposed on ophthalmology, dermatology, audiology, neurology, and some major mental health issues around psychiatric holds and substance abuse treatments. So when you're in doubt, check with your state's board. Let's move on to HIPAA compliance considerations for our US-based health clinics. Providing patient care via telehealth does not exempt you from general HIPAA requirements, and in fact, it adds an extra layer of complexity. Telehealth platforms must comply with the Health Insurance Portability and Accountability Act, or HIPAA, which mandates strict guidelines on how patient data is handled, shared, and stored, including encryption standards for communications. And if the clinic uses third-party services, including the telehealth platforms themselves, but also for things like cloud storage, billing services, and so forth, it must have a business associate agreement, or a BAA for short, in place with those providers to ensure that they also comply with HIPAA regulations. This segment could quickly spin out of control, so I'd like to address a few of the most common ways that practitioners fall out of compliance and suggest a few best practices to implement in order to avoid mistakes. But this is no way intended to be comprehensive. Telehealth platform selection. So you need to be cautious when using popular video conferencing platforms like Zoom, Skype, and FaceTime because they are not necessarily HIPAA compliant by default, and they may need to be specially configured or upgraded to healthcare specific versions. You should also make sure the platform complies with the Americans with Disabilities Act, or the ADA, requirements, providing services such as screen readers for visually impaired patients or real-time captioning for hearing impaired patients. And have a backup plan in case the technology fails, even if that's just switching to a voice call and rescheduling the appointment. Above all, be aware that basic encryption for general use platforms may not meet HIPAA requirements for protecting patient information, particularly without a business associate agreement in place. This leads to the second common and costly mistake, which is assuming that third-party vendors will comply with HIPAA without getting a formal BAA in place. If you don't have a signed business associate agreement, you can be held responsible if the vendor mishandles patient data. You're at a greater risk of a patient data breach if you store telehealth session recordings or patient notes on unsecured devices, cloud services, or personal computers without proper encryption or security protocols. This is true for all patient data, of course, but telehealth can blur the lines of personal and professional, and practitioners can tend to get sloppy. Any storage or transmission of patient information needs to comply with HIPAA security standards, including secure, password-protected storage locations with access limited only to authorized personnel. The lines of professionalism can get blurred further when practitioners conduct telehealth sessions in places where patient information could be overheard or seen by unauthorized individuals, whether that's a fully public area, a shared office, or even a home office in a busy household with minimal privacy. This should be obvious, but your team always needs to conduct telehealth sessions in private, soundproof areas. Finally, you need to update your privacy policies to reflect how data will be collected, used, stored, and shared during any virtual appointments. You'll also need to obtain patients' informed consent, specifically explaining the risks and limitations of telehealth services. Describe how telehealth works, potential risks, including data breaches and technical failures, patient rights, and limitations of remote care versus in-person care. Just using your existing forms and processes from an in-person appointments can leave problematic gaps. Now again, this is not exhaustive. And remember, some states will have additional and more stringent privacy and security laws relating to telehealth, which you may need to comply with as well. Now let's talk about some of the reimbursement and insurance considerations for telehealth services, getting a bit into the nuances of payment rates, policies, and claim validation requirements. Once again, due to time constraints, I'm just going to hit the highlights. Now, since you have bills to pay and payroll to cover, let's talk first and foremost about how reimbursement rates for telehealth compare to in-person appointments. Some states have telehealth parity laws that require insurance providers, both private and public, to reimburse telehealth visits at the same rate as in-person visits. However, this doesn't apply universally, and many states either don't have such laws or allow insurers to reimburse telehealth services at a lower rate. Medicare has made significant strides in telehealth reimbursements, especially after COVID-19. As of now, Medicare reimburses telehealth services at the same rate as in-person visits, though this could change as pandemic-era policies evolve and the new administration is in place. Medicaid rules, however, vary significantly by state, and some states may not reimburse at the same level. Private insurers are more varied in their reimbursement rates. Some insurers may reimburse telehealth at lower rates, especially for non-acute or follow-up care, as they argue telehealth incurs fewer overhead costs. This is something you should check with each specific insurer that your clinic works with. And some insurers may reimburse certain services like psychotherapy or follow-ups at full rates, but offer lower reimbursement for initial consultations or diagnostic visits conducted via telehealth. The level of reimbursement may also depend on whether the service is conducted via streaming video or by voice call, and the latter of which is often reimbursed at a lower rate. Now, beyond considerations around potential changes to reimbursement rates, you should also be prepared that insurance may impose additional requirements and restrictions when it comes to telehealth. For example, some insurers, especially for certain specialties like psychiatry, speech therapy, or physical therapy, require pre-authorization or prior approval before covering telehealth services in order to ensure that the service is deemed medically necessary and falls under the covered services. These insurers also often require additional documentation around justifying medical necessity. This means detailed notes must accompany claims in order to show why the telehealth was appropriate for the situation. Some insurers may be more stringent with telehealth visits than they are with in-person ones in terms of justifying coverage. Some insurance plans may also impose restrictions on telehealth services based on the patient's location. For instance, Medicare previously limited telehealth services to patients in rural areas or those receiving services at specific healthcare sites. Many of these restrictions were lifted during the COVID-19 pandemic, but it's important to confirm current geographic requirements, especially for rural patients. And finally, insurers may require that clinics document patient consent for telehealth services. As I just discussed with respect to HIPAA and privacy law compliance, informed consent documentation must explain the risks and benefits of telehealth, and the consent documentation should be made a part of the patient's record, particularly for Medicaid or other public insurance programs. Now let's talk about patient eligibility and coverage. Even today, not all insurance plans cover telehealth. Some older or lower tier insurance plans may not cover remote services at all, or they may impose significant restrictions on which telehealth services are covered. It's crucial to verify the patient's plan to determine whether telehealth is covered and under what circumstances. And some insurance providers limit the number of telehealth sessions covered within a specific time period. Many insurance plans only cover a certain number of telehealth sessions per year, particularly for therapeutic purposes, so it's important to track usage and verify limits with the insurer. Insurers sometimes require documentation of the patient's physical location during the telehealth visit. For example, Medicare requires that the provider document the patient's location, that is, whether they're at home, at a rural clinic, or so forth, at the time of service. This can affect claim validation. And of course, that in turn ties back to my initial comments about ensuring that your providers are licensed in the state in which their patients are physically located. Your insurer may validate licensing before reimbursing claims, and non-compliance can lead to claim denials. Finally, be aware that insurers may scrutinize telehealth claims more closely than in-person visits, especially if there's a question about whether telehealth was appropriate for the patient's condition. You may be required to provide additional validation to show that the service met the standard of care in a telehealth setting. They'll also be concerned about fraud and overuse of telehealth, so make extra sure that you don't upcode or duplicate billing, and you have processes to verify the patient's identity at the commencement of each telehealth session. Okay, thanks for hanging in with me up to this point. Most of this is, or at least it should be, duplicative of what your practice is doing for in-person health services. So you should have procedures and systems in place already for much of this. The key is going to be mindfully integrating telehealth services into the existing structures, with mindfully being the operative word. You'll need some thoughtful tweaks to get yourself fully compliant. Now let's go through just a few more administrative and operational considerations. First, ensure that your malpractice insurance covers telehealth services. Some policies may not automatically include telehealth, and you may need to upgrade or modify your policy to reflect your telehealth operations. Don't just make assumptions. And since malpractice laws vary by state, offering telehealth across state lines may expose the clinic to legal risks from multiple jurisdictions. It's essential to assess these risks with legal counsel and with your insurance provider. Next, be mindful of documentation and record keeping. Almost every medical and allied health practice I've worked with seems to have that one practitioner who is a great technical expert and caregiver, but cannot, for the life of himself or herself, seem to abide the practice's policies around documentation and record keeping. And telehealth seems to exacerbate this. So use your telehealth rollout as an opportunity to reinforce the importance of internal policies around electronic health records, visit notes, claim submissions, timing requirements, and more. Make sure that telehealth encounters are seamlessly integrated into your existing electronic health records or EHR systems to maintain accurate and comprehensive medical records. Providers should be instructed that they must document telehealth visits with the same level of detail as in-person visits, capturing patient symptoms, discussions, and any treatments or prescriptions. And again, implement secure methods for storing any video or audio recordings, if they're allowed, and ensure that patient data is encrypted both at rest and in transit. Finally, you'll want to make sure that your staff and your patients are prepared to use the technology and you have proper continuity of care protocols in place. If this were obvious to everyone, I wouldn't have to say it here. Make sure providers and support staff are fully trained on the telehealth platform itself, including how to handle technical issues, how to interact with patients virtually, and how to ensure a professional virtual environment. No matter how smart they are, not all of your doctors or other professionals will be tech savvy. And the remote environment often leads people to dress, speak, and act much more informally, perhaps in ways that are not befitting to the dignity of the medical profession. It is absolutely appropriate to set expectations and guidelines with your staff in advance. You'll also need to provide detailed instructions for patients on how to access the telehealth services, what technology they need, and any preparatory steps. For example, do they need to create an account and a password? Do they need to test their internet connection? Again, don't assume that what's intuitive or common sense to you is going to be so for everyone. Regardless of your specialization or service offerings, you'll need to determine clear guidelines for when telehealth is appropriate and when patients should be referred to in-person care. There should also be a protocol for scheduling follow-ups, either virtually or in person, depending on the patient's needs. And finally, establish protocols for how the clinic will handle emergencies during telehealth visits. This might include, for example, ensuring that providers can quickly determine a patient's location and contact local emergency services if needed. By considering all these factors as a starting point, your clinic can establish a telehealth service that is not only legally compliant, but also effective and accessible for your patients. Each of these points may require consultation with legal and IT professionals to ensure the smooth and compliant rollout of telehealth services. Medical and allied health professionals. Let me know in the comments what legal and business topics are of particular interest to you and your profession.